Welcome to Purposes and Responsibility of Courts. My name's Kimberly. I'll be your host. If you have a question during the session, raise your hand. I'll bring a microphone around because we are live streaming this. So if you just shout out your questions, it may not pick it up for the people who are watching at home. I am going to introduce our speakers for today. We have Rhonda Gardner with the Office of Executive Secretary, Supreme Court of Virginia, and Dr. Carolyn Kirkpatrick, also of the Office of the Executive Secretary, Supreme Court of Virginia.
Oh, thank you very much. Just really quickly, before we get started, we will have a few small activities during the presentation that will ask you to talk with your neighbors. So if you don't have neighbors, you might want to move towards folks so you can have those conversations, and we'll certainly prep you for that. Thank you for the introduction, and Caroline and I are happy to be with you today. We're from the Office of the Executive Secretary of the Supreme Court of Virginia, which is just a fancy way of saying State Court Administration Office. And we teach this course back home. It's a 2.5-day course, and so certainly we only have an hour and 15 minutes, so that makes it a little bit more difficult to get through the material, but we're going to move through it as fast as we can. Just a few comments about the CORE program. I've been asked to cover this at the beginning, the CORE Champion Achievement Program. What is the CORE? It is a curriculum that was established by the National Association of Court Management. It contains 13 competencies. They're categorized here in 3 areas: principles, practices, and vision. Starting with principles, that's what you're doing today. That's a great place to start. We go back to basics, right? Back to the purposes of courts, very important. And this curriculum shows up throughout many of the educational opportunities that you'll see with NACM as well as with the National Center. Some of you are familiar with the Institute for Court Management and the courses that are offered through that program. We have the Certified Court Manager, Certified Court Executive. Those culminate into the fellowship program, the Fellows Program. Hopefully you're aware of that. If you have any questions about the CORE programs, please come see us after this session. We're happy to answer any questions that you have. You'll notice some of the key curriculum areas here. You recognize those. It's a lot about what we do every day about court administration. So what does the CORE Achievement Program seek to do? It seeks to get more of this information about the CORE out to court professionals, right? Expose you to the CORE. An opportunity at conferences to hear more about best practices in court administration, and certainly to recognize your attendance in these courses through the program, and I'll talk a little bit more about that. So there are several certificates that you can work towards in the CORE program. A lot of this information is available to you, or most of it, on the association's website. You can also email core@nacmnet. I think it's gov or org. I'm sorry, org. I'm so used to gov. And get more information or ask questions about the programs. So this course meets one of the competencies in the program. So by attending this, and I'm going to tell you a couple extra steps you have to go through, and you meet one of the competencies. So attend the qualified session like you're doing now. And then in the app, you'll see there is a structured response that you will fill out and send in for the work group to review, and they'll approve that response, and then you'll be awarded a certificate for this one competency. You can also email NACM, the CORE program, the email address I gave you earlier, and they will also supply you with that structured response form. Once you've completed all of the curriculum areas, that's 13, you can apply for the Champion Achievement Award. That requires a small article where you're going to write how the core program has benefited you, how it benefits you at your office, and what you plan to do with the information and knowledge that you've received from the core curriculum. And then a work group will determine your eligibility to receive the award and possibly publish your article in the Court Express. So a great opportunity not only to be recognized and to receive that achievement, but also possibly to be published. Again, if you have any questions about the program, please come see us after. And you'll notice on the agenda that there are opportunities throughout the conference for you to attend the core classes. Okay, we're going to get started. Purposes and responsibilities of courts. And I love the fact that Greg really set us up for set our mindset, or got our mindset where we need it for this particular course. Again, we teach this back home, and I don't know that we've ever had students come out of this experience and say, you know, I didn't need to hear that. Instead, they're infused, again, with energy about their role in the courts, about the incredible purpose and mission of the courts. And they always say to us, I wish everybody in my office could go through this program so that we could have the same conversations about what we're doing here. A few things have changed about the courts in the last 20 or 30 years. I'm in my 29th year in the Virginia Judiciary. I'm very proud of that career. I've seen a lot of change. I'm sure you've seen a lot of change, whether you've been in the court system for 30 years or 5 years, right? The last 5 or 6 years have been pretty challenging for us in the court system, and we've seen a lot of change, a lot of good change very often. But what are some of the things that we've seen? Technology, right? Certainly technology has changed. We've had to keep our skills sharp in that area, bring new ideas. Certainly that's very important. What about accountability? I can tell you that in the late 90s, I didn't answer the questions that I'm answering today from the public. They are much more savvy, much more interested in doing business with the courts. They see us as a service organization, which is wonderful. That's what we are. And as a result, they ask questions to understand our practices and our procedures, which has forced us to be a little bit more transparent. That's a good thing. But accountability, we're held accountable more to the public than we've ever been. So that's a big change. What about data? Data, right? We used data in the late 90s when I was a clerk of court for a family court, and we used data quite a bit, but not like we do now. We are driven by data. Data governance is a big part of our efforts, right, to use that data more effectively to assist courts. And we are encouraging courts to make data-driven decisions. So those are just a few things. I'm sure we could spend an entire day talking about how courts have changed. So in our time together, we are going to, and I'll challenge you, certainly we want you to think about your court organization, how this information affects you, your role in the courts. This is a critical thinking class, right? It's meant to be thought-provoking and help you with your role and purpose in the courts. But I also want you to think about the colleagues back home, your organization, and sharing this information with them. This course is available online for the National Center. We're going to talk about the major purposes of courts, the traditional purposes, and certainly there are many more past that. The foundational concepts and historical perspectives, what the Founding Fathers were thinking when they designed our government and how the judiciary plays into that. Important concepts like rule of law, procedural justice, equal protection, due process, and how what you do every day in the courts affects those, either positively or negatively. And talk about the judiciary as the third branch, that judicial independence, impartiality, the importance of those and protecting those, as well as, again, bringing back the purposes back home with challenges in mind that we're facing today in the court system. So this is our first activity, and we'd ask that you could do this in pairs or in a small group. Just going to give you a couple minutes to think about, what if there were no courts? What if my community did not have a court system? What would be different in society if courts did not exist? Think of 2 or 3 things, jot them down. We'll take a few volunteers when we're done. So just a couple minutes.
Hi, Esther Joe.
Hi.
My middle name's Joe. It's Rhonda Joe.
Hi, Joe.
I got the name back when double names were real big. My parents were into them, so.
Mine too. Thank you.
You too. Seconds.
Okay, we're going to come back together. See, we're going to stick to our time. Do we have any volunteers, people who'd like to share? What would happen, what would be different in our society if courts did not exist? Okay, I'm going to come back here for a couple.
For our team, we came up with no accountability.
No accountability. Okay, that's a great one.
Complete anarchy.
Chaos.
Mass chaos. Absolutely. Go ahead.
Complete anarchy.
Anarchy. Okay. Anyone else?
Companies that make robes would go out of business.
I don't think we've ever heard that one before, but I'll tell you one comment we often get in this class is The Purge, which I've not actually seen that movie, but we kind of laugh about it. It's always one of the group comments.
And we wouldn't have jobs, which gets close.
That's right. That's right. We have one more over there, Caroline, if you want to just grab him. Thank you.
I think law enforcement would probably have more authority.
Yes, we see a lot of people taking advantage of the situations, trying to resolve things on their own. That might be very difficult. Mass chaos, certainly. We just don't imagine a world without courts, do we? We don't imagine that. But it's a good question to get started because we have a system that at times has seemed fragile, right? When it comes to having the public's trust and confidence in us, seeing our value to be able to do our jobs. So it's something to keep in mind. Very important. Thank you for those answers. So in the early 70s, a man by the name of Ernie Friesen, first court administrator, first dean of the Judicial College, he, and you may recognize that name, it comes up often, he gathered court professionals together, judicial officers to talk about court administration and the purposes of courts. And they came up, it took lots of working together to come up with these traditional 8 purposes of courts. There are many more, certainly, and as the court administration has evolved and courts have changed, those purposes have been added to. But we're going to talk just briefly about these first 8 purposes. To do individual justice in individual cases. Yeah, it is the role of the judiciary and the role of the judge. They do justice by applying the law to the facts in individual cases. The key word there is individual, right? Every case gets the attention it deserves. Second purpose, to appear to do justice in individual cases. So it's fundamentally important that we do justice, but not that we just do justice, that we also appear to do justice. A little bit more difficult to achieve. Certainly at different times we can feel that, what the public sees as fair and not fair. We're going to come back to this concept of perception because it's tied so closely to what we're trying to take hold of and sustain, which is public trust and confidence from the public, right? From the people that we serve. And with all of the challenges courts are facing, that perception to do justice, it's very important that we come back to that. Provide a final resolution of legal disputes. We just talked about what would happen if we didn't have courts. People would take it upon themselves to resolve their problems. It is our role in the court system to provide a forum for people to come together to resolve disputes and to get on with their lives. We bring that finality to them so that they can move on. Very important. And sometimes it doesn't look like a courtroom, right? Sometimes it looks like a mediation session. That's one of the things that has evolved over time. To protect from the arbitrary use of government power, you're going to hear a lot about that from Caroline. She's going to go over some of the evolution of the judiciary. But our founding fathers knew well about the abuses of power. And our system is constructed to provide that balance, right? And in the court system, we're here to protect people because everyone in government should be held accountable too. And our founding fathers knew that. And so that's why we have our system of government. To make a formal record of legal status, I like to tell people who don't engage with the court system, most of what goes on in the courts doesn't happen in a courtroom, right? The clerk's offices, they work really hard to put together the cases and the paperwork, to put things on record, because if it's not in the order, it didn't happen, right? We have to get that right. That's what we're experts at in the court system, in court administration. And this is 70% of the work, possibly, is making that legal record. Deterring criminal behavior. I feel this is all about how expeditious we are If we're expeditious, if we process our cases timely, if we have our hearings timely, that's the deterrent, right? When justice is delivered effectively, but also efficiently and expeditiously. That's why we tap on those brakes when we see that law enforcement officer at that checkpoint, because we know it's coming if we're speeding. It's the same thing, right? So very important understanding how delay affects all of these purposes, but especially that one. Rehabilitating persons convicted of crime. This is probably one of the most talked about purposes, because there are people who have differing opinions of whether or not this is a role of the courts. Certainly over the last decade, with the rise of specialty dockets, right? We do see that as a service that we provide, and we do see achievements made in those areas of court work. Rehabilitating persons convicted of crimes, giving them an opportunity to return to society as law-abiding citizens, very important. And of course, when they can't, to separate them from society. Okay, very good. So 8 purposes. We will talk about those more and more. It begins with us. I love that, what Greg said earlier this morning. It begins with us. And we're going to talk about a lot of concepts, including these purposes, and again, going back to procedural justice, a lot of what we do is in that area. And these types of sessions fuel you as a court official, fuel you as a court professional. It's about feeding your inner purpose in your work, which is so important to keeping the momentum and also driving the impetus. So I like the fact that he started us out with that.
And Rhonda, if I could just add, in Virginia, we have a wellness coordinator in the Educational Services Department. And she talks a lot about, she's an attorney, she goes out and talks to other bar associations, judges, clerks, others in the judicial system. And she talks about the 6 dimensions of wellness. And I'm sure many of you have seen that or heard of it. And one of them is occupational wellness. And it's everything that you have a purpose, a reason to get up and go to work, and you know that purpose, and you can see a difference from what you do on a day-to-day basis. And so in the occupational wellness realm, we should all be doing pretty well, I would say, in terms of our jobs, and maybe not so well on the other 5 dimensions, but that one we should be able to check the box. So just wanted to add that. Thank you.
Thanks, Caroline. So talking about purposes is a great segue to mission, because a mission statement is how a court communicates their purpose to the public. How many of you have a mission statement at your court? Okay. How many of you know your mission statement at your court? Okay, a few. I agree with Greg. Get a poster made of that mission, put it up in your office. Talk about it, encourage people to understand it, because you'll see some values listed on this slide. Again, it's how you relay the values that you work with every day. And you see some words here: integrity, fairness, independence, respect. What are some other words that come to light in mission statements? Okay, stewardship, that's a good one.
Sorry about that. Stewardship.
There you go. Anyone else? What are some other words that come to mind?
Timely.
Timely. Absolutely.
And we can repeat them as well if you just want to throw it out. Transparency.
Transparency. Very good. I'm sorry.
Trust.
Trust. Absolutely. Trust. Trustworthiness. Right. So mission statements are important. They drive us. We don't go to work every day thinking, what if courts didn't exist? Or, I hope I fulfill my purposes today, or I hope I'm exemplifying the values that are stated in our mission statement. We don't necessarily go to work every day thinking that. Being reminded of it while we're at work, talking about it with our colleagues, exemplifying that, setting the example is very important. So, what purposes and roles of the courts can you distinguish from your mission statement? I'm going to give you just a couple minutes, again with your neighbor, to talk about that, and then we'll take a few volunteers. What purposes and roles of the courts can you distinguish from your mission statement? And you can use your state mission statement if that's needed.
How many people are here for that? Right. We're working on the floor. Yeah, jump in wherever, because I'm worried about this. 10:56. Yeah, but like I thought, I talk fast. Stop me if you.
Okay, let's come back together. Would anyone like to share what you discussed in your group? A little bit trickier question to work through, but would anyone like to share what purposes and roles of the courts did you glean from your mission statement? Anyone?
We talked about both of our mission statements, and we thought that they included most of the, if not all of the purposes and roles the way they're lined out. And my particular one, it's to administer justice and restore wholeness in a manner that inspires public trust. Okay. So with the administration of justice, you can look at all of the case management issues. With the restoring wholeness, you can look at our problem-solving courts, our juvenile court operations, our community services, and when you are establishing public trust, doing things in a manner that inspires trust, all the accountability issues come up forward and transparency issues.
Okay, very good. I like the comment about you can really drill down into some of the things in our mission statement. Usually you see those in the visions, right, that come out from your mission statement of what we're trying to achieve and in what areas of the court, like case flow management or reducing delay or providing services to individuals through maybe our specialty dockets or maybe through other referrals. So very good. Thank you very much.
And we have one from the live stream.
And Erica says, respecting the constituents that visit the courthouse and provide access to justice timely in a fair and just way.
Okay, great. I like the courteous and respectful comment because that goes a long way. When we start talking about procedural justice, was I treated the same way everybody else was treated in the courthouse? People are very aware if that is not the case. And some of that has to do with how courteous and respectful we are, how helpful we are, anticipating the needs of people coming to the court. All of that is very important. So great comment. Thank you. Okay, I'm going to go ahead and turn it over to Caroline. She's going to get started on some of our history lesson.
Thank you, Rhonda. And you've set us up beautifully for a lot of concepts and foundational principles that we're going to talk about as we as we zoom through history. We're not just gonna proceed. We're gonna kind of do a quick zoom through in the few minutes that we have today to do this. First of all, I know a couple of our reporters, and we thank them for their help, are here from Nebraska. Anybody else from Nebraska and know where this is? Yes, please tell us. Chimney Rock, right. So in my Google search, Rhonda and I found this scenery, and we thought it really does look like a source of liberty and justice. It just gives you that pioneer kind of feeling. The pioneers were heading west, and this was a source of beauty, and they were glad that they were headed towards something that they hoped was better for them, right? So that's Chimney Rock. We're not here that long in Nebraska, but if you have a chance, certainly looks like a beautiful place to visit. How long is that? 7 hours? Okay, well, I hope you don't have any plans for the end of the week, because
say, please don't leave the session now.
Right. Yeah, you can't leave now. So we're gonna talk about there is a good reason not to use AI and Google, and right, like if you're going to Omaha, here's what you should do. Well, you need 7 hours. Anyway, sidebar. So we're gonna talk about sources of liberty and justice. Some of the foundational principles, again, that got us to where we are today in terms of our courts and our judiciary. So we'll talk about the common law model, the civil law model. We'll look at the Constitution a little bit, the Declaration of Independence. We'll look at the Federalist Papers. And I see so much expertise in this room. So if something strikes you, I'm sure many of you teach this yourselves. Please just raise your hand and we'll come to you. We don't have a ton of time for interaction, but again, when we teach these classes, we have everyone write down when the groups are doing their introductions how long you've been in the court system, and we always get like 300-400 years of experience in the room. And I just like to point that out, that yes, we're up here, but there's a lot of expertise in the room. So let us come to you with a microphone if you have something that you want to share, and that goes as well for our folks online. So I'm the Educational Services Director at OES. So I have on my education hat a little bit, and I'm going to have to point some things out along the way. And some of you may be as well interested in that kind of aspect of this. And again, Rhonda pointed out, this can be some really, really good, rich material for newer employees. If it's not already part of your onboarding, it should be. And another sidebar, the National Center for State Courts, I'm on a subcommittee, I guess, working. We're trying to put together a module that's a little bit shorter. Jude is on that subcommittee as well. And something that's just a little bit shorter, not 2.5 days, that you can, again, infuse into an onboarding program or some type of module that we could all share with new employees when they come to take their position at the court. So hopefully you'll hear more about that. And that will be a tool that you can use going forward with this same content, this same material. So we'll start with the common law model. This was came from Europe, spread throughout the British colonies, spread throughout the colonies, and we're going to contrast this with the civil law model. We're talking here about judges applying precedent, right? So we're looking back in the courts. Often we're applying precedent, and if you contrast that with the civil law is more of there's a legislative code, a group of statutes, complex code that the judges are just applying to the case before them. Common law is adversarial, right? We have attorneys in front of us, often very adversarial. In the civil law model, which again we'll see after this, it's more of an inquisitorial system. The common law model, much like we've already mentioned, the judges are neutral. You always hear the judge calls the balls and the strikes, right? The judge is the referee. The judge is neutral. And we'll contrast that momentarily. And then the parties and the attorneys, right? They're bringing all the information, the evidence to the judge. They are the ones who are more active and taking a role in the case, presenting the evidence and such. civil law model from ancient Rome, the judge plays a much more active role. That's kind of the big piece of this, the big difference. The judge is not a potted plant. Sometimes you hear that. They're playing an interactive role. They're asking questions. This is inquisitorial versus the adversarial that we saw in the common law model. The parties and the attorneys are playing a much smaller role. They're more supportive. They're not as active in terms of bringing information, evidence, and such to the judge. What else? Parties. Yep, already said that. All right, so those are two models that we've talked about. Let's look at this quote. We're moving, again, I said we're going to zoom through history. Now we're at 1776, right, in the Declaration of our freedom. This quote is from the Declaration of Independence. It says, "He has obstructed the administration of justice by refusing to assent his laws for establishing judiciary powers." Who is he? The king, yes, right. So King George III, the colonists came up with, I think it's 27 in the longer course. There's an activity that we do with, it's called the Train of Abuses, and there are 27 that were listed. This is one of the ones that the colonists put forward. And again, the king, of course, did not want them to have courts or have a way to have their voice heard in the government. So absolutely against establishing a judiciary. And so that certainly was not established early on. So again, 1776, Declaration of Independence. I said we were moving quickly, but now we're moving backwards. That wasn't the first time that there was an assertion of people asserting their rights against the king. In 1215, who knows it? What's the event? Yes, the Magna Carta. All right, good job. That was really the first time that we see the nobles asserting their rights and asking for things that they thought they should have. They mainly a voice, right? They wanted to be heard. They wanted to not have a rule of man. They wanted rule of law, and we'll talk about that in a little bit. So the Declaration of Independence is actually much of what we see there came back 500 years before that in 1215 with the Magna Carta. And the Magna Carta gives us one of our very important foundational principles, which is limited government. And what we mean by that, of course, is that the colonists wanted their voice heard. When we progress that far in history, they wanted their voice heard. They wanted a say in how things were handled, especially in terms of their disputes. They wanted a way to handle their disputes. And again, not just the king deciding. The king must respect their rights and abide by the rule of law. So what's the opposite of the rule of law? The rule of man. Yes, the king, right. So we're contrasting, doing a lot of that in this hour this morning, the rule of man and the rule of law. And so the rule of man, again, we're talking about an arbitrary individual making decisions, and the rule of law, everyone is under the rule of law, including that man. So that's what we're talking about when we distinguish between the rule of law and the rule of man. And all of that comes from the Magna Carta in 1215. And another little tidbit, the National Center, the logo, that tree that is on there, we like to share that too when we're in our class. That is the infamous tree where the Magna Carta was signed. And so all this is weaving in. And again, these are things that you can share with new employees and use in other instances. But Magna Carta, the 800th anniversary, I think, was a few years ago, and we really went all out for that. We happened to be teaching this class. We had a Magna Carta cake, and it was just, can you imagine what the baker thought when I went in to pick up my Magna Carta cake? Like, she's really exciting, I bet. So, but yeah, you can have a lot of fun with this. And again, these are foundational principles that often, now we think about them all the time, of course. I do, Rhonda, wake up and and drive and the way to work and think about my purpose and my role and everything. No. But these are principles that you really can use and infuse into all parts of the job. It's not just inputting data, right? It goes so much deeper. So have some fun with it as well. This is our first video. If it works, we didn't have our PowerPoint this morning, so this should work for us. We deserve that, right? And it's about the rule of law. And jot some notes down, or if you have any thoughts as we go through, we'll ask you if you have anything to share or what you were reminded of perhaps on the other side of this. It's about 5 minutes.
I would describe the rule of law as fairness. It is a set of rules that everyone needs to abide by.
We can't have peaceful interactions with one another without the rule of law.
Our social compact is based on the idea that we are each and every one of us accountable to the law.
Your right to swing your fist stops just short of my nose. And that's what the rule of law is meant to do, is to find that boundary between expression, freedom, liberty, and everything we want to do, and when we hurt others.
For example, this morning, I went to buy a breakfast sandwich, and everything that I did to get that sandwich was related to the rule of law in some way, in the sense that I was able to cross the street safely because I knew that the people driving their cars were going to stop at the stoplight. And I had trust that they were going to do that because there would be consequences under our law for that.
I can get up in the morning and know that the dollar will be accepted down the street at the grocery store. I can go to the post service and expect that I can retrieve my mail and that someone won't take it, or that someone won't view it without my permission.
I then go and buy the breakfast sandwich. I know that the company I'm buying the breakfast sandwich from has to follow the rule of law and with regard to food regulations, so I know that the food I eat is going to be safe. The company similarly can't overcharge me because there's going to be penalties for that.
It affects our quality of life in that we're able to sleep at night knowing that tomorrow morning we'll wake up, the stock market will be working, the speed limits will be enforced, the laws will be applied to each and every one of us. One of the great things about the rule of law is the protection of minority rights. Our Constitution has embedded within it a counter-majoritarian principle. What the Founding Fathers said was to protect us against the tyranny of the majority.
The most important thing that I felt from taking the oath was to make sure that I applied the rule of law in a fair manner to everyone.
And what that means is that 51% of the people or 90% of the people can't deprive the minority of certain inalienable rights: the right to worship, the right to speak, the freedom of the press, the right to keep and bear arms, the right to be free from unreasonable searches and seizures.
No matter what their background, no matter where they came from, no matter what they look like. And that's what I try to do every day, is to apply the law fairly and evenly to every party that's before me.
We are bound to follow the law. The law is the statutes, the law that is written by people who are elected by the people. And we have to comply with that law. We have to follow the Constitution.
New citizens swear an oath, not to the flag or to the president or to America, but to the Constitution, to our supreme law of the land.
The rule of law means that everybody understands what the law is, and everybody also understands that they will be held to that law, and that there's no way of getting out of that, including the government.
Rule of law means that the laws are public. People know what they're expected to do, and you can rightfully hold them to that knowledge. Now, I'm not saying you could go out in the street and give a quiz about the U.S. Code to every person who's walking by, but the public nature of the law is critical, and the public nature of the judicial process is critical.
After reading a lot about Greek history, Roman Republic, Roman Empire, all the way forward up to the present day, it was interesting to see what made civilizations thrive and what made civilizations fail. And the only civilizations that thrived were civilizations that emphasized the rule of law.
Okay, you want to start with our, I love this video right here because we've talked about these kind of abstract concepts, and then we talk about, and then we see it applied. So like colloquially, or in this video that we just saw, talking about breakfast sandwiches and the roads, right? So it's, I like that video right there. What's our comment that we have? If you could share that, please.
Okay. Peter comments, given the fact that the stigma of a felony remains with the person for the rest of his or her life, do we ever truly rehabilitate people in the criminal justice system?
And who is that from?
Peter Kiefer.
Peter, that is a great question. Anyone have an answer for Peter about that? Back there. Great question.
I guess my response to that would be that the stigma imposed on a felon, a convicted felon, is not coming from the government. At the end of the sentence, that felon, now we're going to where they can get their rights restored, and that was based on the public wanting it. At least in Florida, in our state, they're starting to do that. But if the stigma of being a felon is not imposed by the government per se, it's imposed by the people who don't want to be around a felon, so that would be my thing. So as far as rehabilitating them, at some point that convicted felon is square with the house.
Thank you for that. And I feel like we backed up a little bit to the purposes of courts, and we're talking about rehabilitation and deterrence and such. But thank you for that comment, Peter. And so fast forward a little bit back to the rule of law and the video. Did you have any reactions to that? Any thoughts? Anything that really stuck out? It's a great, as I said, just applying it to things that we do every day, driving, having breakfast, buying things at the store. I think it's a really good application of some of the concepts that can sometimes seem a little abstract and difficult to grasp. Anybody seen that before? All right, but yes. Okay, well, good. Well, it's a good one. And again, we're talking about the rule of law in contrast to the rule of man. So we're going back to our history lesson a little bit in the Federalist Papers. The Federalist Papers were written, it's John Jay, James Madison, and Alexander Hamilton. And I think it's 85, if I'm not mistaken, that were written. We're going to talk about 3 here. And they were written, the purpose was for to try to gain support to get ratification for the Constitution. And so the authors, and they all wrote under the name Publius, I believe, and they wrote these papers, again, trying to gather support for ratifying the Constitution. And so we're going to talk about 3 of them. First one is, and you'll see concepts that you've heard of. With new employees, I like to say it's, it may have been a while since you talked about these things in middle school, right? Or high school, and wherever the case may be. But, and now that you're in the courts coming at this from, especially after you've been in the courts for a few years, these concepts certainly mean something much differently than they did back in middle school or high school, right? So essay 51, I love this. If men were angels, no government would be necessary, right? I mean, we could walk out right now. That's pretty intuitive of the founding fathers. And then essay 78, and we'll talk about 17 as well after this, talk about the independence of the judiciary. And this is the quote here again is from Hamilton. There's no liberty unless the power of judging be not separate from the legislative and executive power. So this concept of separation of powers, what's another concept that comes to mind right then when you're talking about checks and balances? Yes. So we're talking about checks and balances and separation of powers and the three branches of government. And the essay 17 also talks about judicial independence as well. And if you're teaching or thinking about these topics today, you have a lot of stuff in the news, right, that you can just pull from, and these concepts. And absolutely, we're not trying to get political here, but don't every time you turn on the news, right, it's about the rule of law or about judicial independence. So to think that the founding fathers were thinking of all of these principles and foundations when they were creating the government it's really mind-boggling that you think about how we're still kind of testing these things today and how they have stood the test of time. So this slide talks about impartiality, judicial impartiality, and judicial independence, and they are similar, right? But they're different. When we're talking about impartiality, we're talking about the possibility of bias or the possibility of thinking about the outcome before you hear all the evidence and such. That's what we mean by impartiality. Independence, on the other hand, is being free to decide the case based on the facts. We tell new judges that you're going to have to recuse yourself for the first 6 months to a year of the cases from your firm, right, where you came from. If you're coming from a law firm, you'll need to recuse yourself. Why? Because, and we go back to the purposes of courts, it might appear to others that if they win all their cases, that the judge is giving them deference and giving them favor because maybe they practice law together. Maybe that's not the case. Of course, we would hope it's not the case if we've just appointed this new judge, but it can give that appearance, right? So we want to be really careful about that, and that's what we mean by judicial independence. All right, so after the Federalist Papers, we're going to move on to the Constitution. There were 10 we had the Bill of Rights, right, with these 10 amendments initially. And you can take a look at the ones that we've kind of pulled out, ones that have to do with our roles as in courts and our roles as court employees. So all of this should look familiar. The 5th, 6th, and 8th, again, were in the first 10, obviously, and the 14th came later. But you'll notice that the 14th and the 5th both talk about what? Due process. Yes, absolutely. So in the 5th, we were talking about the desire to protect individuals from the federal government. And then when the 14th Amendment later came along, we were talking about protecting those same individuals from state government. And we added the Equal Protection Clause to that. So again, all of this back in the Constitution, and we're talking about, we're going to pull some of this out, in particular the due process, and look at that principle a little more closely. I just talked about the 5th and the 14th Amendments. So the 10 due process protections. The first one talks about timely notice. And I suspect some of you right away can relate that to what you do in your positions or to what the person next to you does in your court. It's kind of an easy connection. The 2 through 9 talk about the opportunity to be heard, and that actually goes back to the Magna Carta. And then the last one talks about having an impartial decision maker, whether that be a judge or jury. What are some of the, do you know some of the protections 2 through 9 that, what do we mean by opportunity to be heard? Give me some examples of that. Opportunity to be heard. The right to have what? An attorney. Right to present your evidence. The right to confront the witnesses. All of those factor into the opportunity to be heard. And those, again, are protections 2 through 9. All right, let's look at, I forgot we have this coming up. So I was alluding to that a little bit when we were talking about our roles and our responsibilities. And if you look back at those protections, let me point out a few others that before we get to our activity. We want to talk about your position. What are some others we talked about the right to an attorney, oral presentation of witnesses, access to the courts, the ability to present your case and defend its position. So all of those factor into these 10 due process protections. And what we want you to do now is talk to your neighbor again about how the clerk of court responsibilities, and if you're not the clerk of court or a court administrator, if you're a judge, if you're in security, whatever the case may be, hopefully you can apply your role back to these protections and how you are protecting these individual rights. So do that now for us, please, for a couple of minutes, and then we'll ask some of you to give us examples of how this relates to your position. Need
have an associate.
All right, let's come back together. I love this question, and I'm sure that you could talk about it all day. Anyone want to share what you talked about in your group and enlighten us a little bit about your role? Or, yes, thank you.
Good morning. We talked a lot, and we all felt really strongly about the use of interpreters. So we felt on protection 1, if you fail to send proper notification in the language that the customer understands, then it's really going to set you up for failure when you get to protections 2 through 9, because those individuals are really not going to understand because of their language barrier. So we talked a lot about that, and a little bit about proper training for your personnel. Some of us are in co-located facilities with your prosecutor's office, and even something as specific as if you have network printers and if the wrong information ends up printed on the court side, if court personnel don't understand the red flags of documentation being placed in a file or ex parteing a judge, then that can really set you up for not having the right protections in place and not processing documents in the right manner.
Terrific. Thank you for that. Interpreters talking about wrong documentation. Excellent, excellent examples. Who else? Microphone's coming to you in the back. Thank you.
Sending release slips to the jail, having that constant communication, and ensuring that got transferred properly to not delay somebody's release.
Absolutely. Thank you for that. And we had one online, I believe, and then one right there.
Okay, Erica says accurate and timely record keeping, as the goal is to create, maintain, and safeguard the official case record. And she goes on to say also due process under the 5th and 14th Amendment ensures adequate notice to parties in the case.
Very good. Thank you. Talk a lot about notice. And then there was one more. You want to... Okay, still talking about jail and ensuring transfer of information appropriately and timely. We have some of those issues throughout, I bet, in our courts. These are excellent examples, and again, I'm sure there are numerous others that you have thought about. And hopefully, again, this will give you some thoughts, information, tools that you can use to talk about with new employees, because as we were just hearing up front, there can be issues that, again, if you just sit at a computer all day and type in the case numbers and type in, they aren't thinking that these are people and some of what might happen if this paper doesn't move through this system in a timely and appropriate way. And even if some of us, I'm sure, still have paper. Others, if you don't hit the right key or the right document is not transmitted, or if someone has access to records, confidentiality is so important, right? So all of this can be tied back to some of these foundational principles that we are zooming through this morning. So thank you for that. Excellent examples and input. We have a couple more still on the Constitution, and a couple more. These are 3 references to judges that are in the Constitution, and talking this just makes me chuckle. This first one about good behavior, right? We see a lot in the news these days, in particular our justices of the U.S. Supreme Court. So why some of these protections that were set up, right, to lifetime tenure, and Congress doesn't have the ability to decrease their salaries, and impeachment, the removal process is very difficult. So all that relates back to judicial independence. Again, we've talked about that earlier. So these are just some of the specific references that are in the Constitution that are highlighting that judicial independence. And we could talk about examples. But again, we just wanted to point out some of the references that are in the Constitution that relate to what we do. And the last kind of foundational big piece that we will talk about is the concept of judicial review. And if you haven't read or Googled or looked lately at Marbury versus Madison, again, this is where we get the concept of judicial review, and where the courts really got their recognition, if you will, of being a co-equal branch of government, and having the ability to determine that a law is unconstitutional. So that was the case of Marbury versus Madison. It had to do with appointments in one administration that didn't carry over into the next administration. It's a really interesting case. I invite you to read more about it or do the quick summary on AI. But the concept that we want to take away from that is judicial review. I believe Rhonda is going to talk a little bit more about judicial independence as well. We're not leaving that topic quite yet. Rhonda?
Okay, thank you. I'm going to come get the clicker from you. All right. So again, this time that we have together is meant to be introspective about what you do every day in the courts. So as we look at these three words, judicial institution, or these three concepts, I want you to think about how you carry out your work every day and how that supports the purposes and due process and procedural fairness that everybody is not only treated equally and fairly, but they perceive that they're treated equally and fairly. And also, how do you support judicial independence? And when I hear about judicial independence, I used to work court a lot when I was a clerk, and I saw this in action sometimes with the judges in my court. And, we talked about a neutral arbiter, your disqualification procedures. Are they followed? Are they written down? Are they transparent when judges disqualify and recuse themselves? What about ex parte communication with judges? Those are things certainly that help anchor and support judicial independence. Be thinking about even the smallest details of your work and how that supports what we've been talking about today. And I will give Caroline a round of applause for going through history as fast as she did. She did an amazing job. So great job, Caroline. Judicial institution, by definition, an institution is an organization that has a set of norms, that operates under a set of norms, right? Has rules and follows those rules. And that creates what? Predictability, right? It creates stability. Institutions operate in that way. We know when we're working with that institution what we're working with. If we had watched that rule of law video, just to go back to that for a second, and the judges were all over the place with what rule of law means, or whether or not we should have rule of law or rule of man, that would confuse us, wouldn't it? I think we take for granted that we go to work every day in an institution that operates under some norms. We take that for granted. It's very important. And what we do every day, how do we support that? I think we only have a few. Let me do a time check real quick. I don't want to run over. Okay, so the judiciary as an institution rooted in values and customs. We're here to protect the people coming to the court, their due process rights. When I think of due process, I think when a person receives that summons, does it have all the information in it that tells them exactly what they're being served with? If you were served with the documents coming out of your court, would you understand them? Would you know exactly what to do? That's a good question. Something to think about, right? It establishes and enforces rules and policies, regulations. Again, those are transparent, they're communicated, they're understood, they're equally applied. right? And all of that's related to justice. So we're going to give you just a couple minutes. Again, this is the last time you get to do this, but it's very important. What are some of the challenges that courts are facing today? Because when we ask you to think about the purposes, we ask you to engage in discussions at your office about public trust and confidence, about your mission, your values. We also know that equally important is how do we overcome some of the challenges our courts are facing today. So what are they? Let's identify a few, and also just talk a little bit. I hope I'm excited to see the Roscoe Pound session talking about satisfaction, dissatisfaction with the courts. Are people satisfied today with the job that we're doing in our communities serving them? So we'll give you just a couple minutes and then we'll wait to hear back from you. Okay, we're going to come back together. We're getting close to our time, so I want to be able to finish up with you. All right, so
I can't believe they have challenges.
they have challenges, maybe more than we've got our first volunteer. So, what are some of the challenges?
I would say for our group, trust. And it's one of the reasons is because they don't understand the lingo, they don't understand the process. A lot of times, I know in my role, I am not able to give you legal advice or tell you which way you should go or not. And it's like, okay, well, go to this site, and they still don't understand. So I think it's the process of how to get.
Yeah, that's since I started in '96, that's been one of the issues that court leadership faces, right? Legal advice versus information. There's a lot of information out there that helps courts talk about that issue. And also, we've seen a lot of the information coming from courts put in terms that the public can understand. That I'd start there, is probably looking at your forms and the information you're sharing with the public. Is it digestible, for everyone you're serving? And I believe this strongly because I've been guilty of it and I've seen it, is when we create systems for the public to navigate, we make them hard. We make them hard. So maybe we have to have someone on our team, on our work group, when we build those systems, that helps us understand whether or not, the average person can navigate them. So great comment. Thank you. Any other challenges? Yes.
I'd just like to, what she was saying, build off that. People don't understand the difference between civil and criminal, right? And protection orders, that's a whole thing in itself. Getting people to understand it, getting how does it work, and then getting people to say, hey, this has been a protection order and somebody's violating it. It's different, I guess to say. That's one of the challenges too.
Crossover tribal jurisdictions of certain like protection orders if they're issued through tribes and they live in the city. So
say it again.
My thing is because I'm Native American, tribal jurisdictional law. So if there's a person who is issued a protection order through the tribe, and the tribal member lives off of the reservation, do the police and the law honor that that protection order? So there's for me, I can say that there's a lot of issues in relationships when it comes to understanding tribal law and just the law.
Good, thank you. Yeah, there's a lot that our communities, can get together and work on and invite our stakeholders to talk about, and certainly that is one of them. So I'm being told that we're out of time, so I'm going to skip over and just say there are lots of components to winning this public trust and confidence. And I'm going to encourage you to, look more closely into this curriculum, the purposes and responsibilities of courts, and we hope to see you in one of our classes. So I'm going to go ahead and turn it over to our host.
I just want to remind everyone to go in the app, rate the session, rate the speakers, and do the SRT.